My ex-wife stood in divorce court and told the judge she built my life, that she deserved $8.5 million, half of my company, and my family's fourth-generation cattle ranch. My name is Graham Bennett. I'm 54 years old, and I've spent the last 28 years building Bennett Agritech, from a startup operation in a rented warehouse to an $18 million precision agriculture technology company. I inherited my family's cattle ranch when I was 26 and spent the next 3 decades restoring it from near bankruptcy to a profitable, sustainable operation worth $3.2 million. That ranch has been in the Bennett family for 140 years, passed down from my great-grandfather, who homesteaded the land in 1885. When Catherine's attorney finished presenting their demands, I said nothing. I didn't argue. I didn't object. I simply reached into my briefcase, pulled out a single page and slid it across the table to the judge. Catherine's face went white. Her attorney stopped mid-sentence. That one page was a document Catherine had signed 8 years earlier, a document she had desperately hoped would never surface in this courtroom. Have you ever watched someone's entire strategy collapse because they forgot about their own signed admissions? Leave a comment below about legal documents that changed everything. I started Bennett Agritech in 1997, fresh out of Colorado State University, with a degree in agricultural engineering and $12,000 in savings. The precision farming industry barely existed then. Most ranchers and farmers still relied on traditional methods, uniform field treatment, and educated guessing about soil conditions and crop health. I saw the potential for technology-driven agriculture, for sensors and data analytics that could optimize every acre. The first 5 years were brutal. I worked from a small warehouse space, developing prototype soil monitoring systems and testing them on my family's ranch. I ate ramen most nights. I reinvested every dollar of profit into research and development. By 2002, I had viable products and my first major client, a corporate farming operation in Nebraska that bought 17 monitoring systems. That contract kept me operational for another year while I refined the technology. Catherine and I married in 2003. She was an art gallery manager, intelligent and charming with no interest in agriculture or technology. That was fine. I never expected her to work in my business, but I made it clear from the beginning that Bennett Agritech was my professional focus, my sole entrepreneurial venture. She attended maybe 3 company events in 22 years of marriage. She never asked about product development, never reviewed financial statements, never participated in strategic decisions. When I invited her to client meetings or industry conferences, she declined, preferring to focus on her gallery work and social activities. I documented everything, every business decision, every financial transaction, every asset acquisition went into comprehensive records maintained by my accounting firm. Professional documentation habits I learned early protect against future disputes. The ranch situation required even more careful management. My father died suddenly in 2001, leaving the property to me as the only child interested in continuing the family's ranching heritage. The operation was hemorrhaging money. Outdated practices, declining cattle prices, and years of deferred maintenance had pushed the ranch to the edge of foreclosure. I spent the next 15 years systematically rebuilding it. I implemented rotational grazing systems that restored soil health and reduced feed costs by 38%. I diversified revenue streams, adding heritage breed cattle that commanded premium prices and developing an agricultural tourism component that generated additional income. I invested in water infrastructure, sustainable range management, and conservation easements that provided tax benefits while protecting the land from development. By 2016, the ranch generated consistent profit and had appreciated to $3.2 million in value. But here's the critical detail. The ranch was held in a family trust established by my grandfather in 1953. The trust documents explicitly restricted ownership to direct Bennett descendants and protected the property from spousal claims in divorce proceedings, standard practice for generational ranching families. Catherine knew this from the beginning. I showed her the trust documents before we married. She signed acknowledgement forms prepared by my attorney. The ranch was never marital property, never subject to division. Yet now her attorney was demanding partition rights, claiming Catherine's support during our marriage entitled her to an interest in family assets. The audacity was remarkable. Systematic documentation of legal protections, I was learning, matters more than verbal agreements or assumed understandings. Professional relationships require written evidence of actual contributions and agreed boundaries. Do you maintain comprehensive records of your business and family assets? Share your documentation strategies in the comments. The divorce proceedings began in March 2024, when Catherine filed after 22 years of marriage. Her petition was straightforward initially: division of marital home retirement accounts, standard spousal support. Then Patricia Morgan came into the picture. Morgan specialized in high-asset divorces and had a reputation for aggressive tactics and massive settlement demands. Suddenly, Catherine's claims expanded dramatically. The amended petition demanded $8.5 million in liquid assets, 50% ownership of Bennett Agritech, and partition rights to the family ranch despite the trust restrictions. The legal theory was creative. Catherine claimed she had sacrificed her gallery career to provide emotional support that enabled my entrepreneurial success, making her a de facto business partner entitled to half of everything I had built. The gallery career she supposedly sacrificed had generated between $18,000 and $32,000 annually during our marriage. She worked part-time, irregular hours, primarily with friends who owned the gallery. But Morgan crafted a narrative of selfless support and partnership sacrifice. The preliminary hearing was difficult to watch. Catherine testified emotionally about the years she spent supporting my business ambitions. She claimed she had attended client dinners, which was true exactly 4 times in 28 years. She said she had provided strategic advice, though she couldn't name a single specific recommendation. She described coming home late from work to find me still reviewing technical specifications, making it sound like she had waited up providing support, rather than the reality that she was typically at gallery events or with friends. Morgan presented it as a classic story. Supportive wife enables husband's success. Husband becomes wealthy. Husband abandons wife who sacrificed everything. The judge, a relatively new family court appointment, appeared sympathetic. She asked Catherine detailed questions about her contributions and nodded thoughtfully when Catherine described providing emotional stability during difficult business periods. Then Morgan presented the financial demands with specific justification for each component. The $8.5 million represented half of what she claimed was total marital estate value, including Bennett Agritech's $18 million valuation. The company ownership claim was based on partnership theory, arguing Catherine's support made her a de facto shareholder, entitled to ongoing business interests. The ranch demand was the most aggressive. Despite the family trust protections, Morgan argued that my restoration of the ranch during marriage using marital resources created an equitable interest for Catherine regardless of trust restrictions. She cited obscure case law about improvements to separate property creating marital claims. The judge didn't dismiss any of it immediately. I sat through 3 hours of testimony without speaking. My attorney wanted me to respond immediately, to object to Catherine's characterizations and challenge her claims. I told him to wait. False narratives eventually collapse under the weight of documented facts, but you have to let them fully develop first. People who claim credit for work they never performed eventually contradict themselves when pressed for specifics. Catherine had spent our entire marriage actively avoiding any involvement in my business ventures. She had declined every invitation to participate, every opportunity to learn about the operations. Now she was claiming partnership based on vague emotional support. The contradiction would become obvious, but only if I let her complete the narrative first. Strategic patience in legal proceedings, I had learned from previous business disputes, often provides better outcomes than immediate confrontation. My decision point came during a recess when my attorney reviewed the judge's apparent sympathy toward Catherine's claims. Family court judges, he explained, often favor narratives of spousal support over documentary evidence of actual business contributions. The emotional story of the sacrificing wife resonates more than corporate records showing zero operational involvement. Without compelling contrary evidence, the judge might award significant assets based purely on marriage duration and support claims. That's when I decided to deploy the document I'd been holding in reserve. 8 years earlier, Catherine and I had gone through a previous separation. It lasted 4 months. During that time, she had retained an attorney who made preliminary divorce demands similar to the current claims. To reconcile, I had required one condition: a post-nuptial agreement clarifying asset ownership and business involvement. The agreement, prepared by specialized family law attorneys and reviewed independently by Catherine's own counsel, contained explicit admissions. Catherine acknowledged she had not participated in Bennett Agritech operations. She disclaimed any ownership interest in the company or the family ranch. She agreed to predetermined settlement terms if we ever divorced. The agreement was comprehensive, properly executed, and legally binding. I had kept it secured for 8 years, knowing it might become necessary exactly in circumstances like these. Do you have legal protections in place for business and family assets? Tell us about preventive legal strategies you've implemented. The second day of hearings began with Morgan presenting expert testimony about business valuation and marital property division standards. Their expert argued that spousal support contributions create equitable interests, regardless of direct operational involvement. It was compelling testimony, backed by selected case citations and theoretical frameworks about partnership marriages. The judge asked detailed questions about precedent for awarding business interests based on emotional support rather than documented business participation. Then Morgan rested their case, confident they had established Catherine's entitlement to massive asset division. My attorney stood and asked the judge for permission to present one exhibit, just one. He handed copies to the judge, to Morgan, and to Catherine. The courtroom went completely silent as they read. The post-nuptial agreement was 15 pages, but page 7 contained the critical language. Catherine's signed acknowledgement stated, "I, Catherine Elizabeth Bennett, acknowledge that I have not participated in the business operations, strategic decisions, or financial management of Bennett Agritech during our marriage. I have declined numerous invitations to become involved in business activities and have chosen to pursue independent professional interests. I hereby disclaim any ownership interest, partnership claim, or equitable interest in Bennett Agritech, recognizing it as the sole entrepreneurial venture and property of Graham Bennett. Furthermore, I acknowledge that the Bennett family ranch is held in irrevocable trust, with restrictions preventing spousal claims, and I disclaim any present or future interest in said property. In the event of divorce, I agree to predetermined settlement terms outlined in Section 4 of this agreement, accepting said terms as full and complete resolution of all marital property claims. The agreement was dated April 14th, 2016. Catherine's signature appeared at the bottom, witnessed by 2 independent attorneys and a notary public. Section 4 specified settlement terms. Catherine would receive 50% of marital home equity, 50% of joint savings and retirement accounts accumulated during marriage, and 2 years of transitional spousal support equal to her average annual income during the final 5 years of marriage. Total projected value, approximately $180,000. The agreement included specific language preventing future claims against business assets or family trust properties. Catherine had signed away everything she was now demanding. The judge's demeanor changed immediately. She looked at Catherine with questions that were no longer sympathetic but pointed. When did you sign this agreement? Were you represented by independent counsel? Did you understand what you were signing? Morgan frantically requested a recess to examine the document and consult with Catherine. The judge granted 15 minutes. I watched Catherine and her attorney through the glass walls of the consultation room. Morgan was clearly furious, gesturing emphatically while Catherine sat with her head in her hands. They hadn't known about the post-nuptial agreement. Catherine had apparently never mentioned it to Morgan when they developed their litigation strategy. Now their entire case was contradicted by Catherine's own signed admissions from 8 years earlier. When we reconvened, Morgan tried to challenge the agreement's validity. She argued Catherine had signed under duress during emotional reconciliation. My attorney produced the file from Catherine's independent attorney, who had reviewed the agreement before she signed it. That attorney's notes documented 3 separate meetings, where he explained the implications and confirmed Catherine understood she was disclaiming business and property interests. Morgan tried arguing the agreement was unconscionable because the settlement terms were inadequate. The judge noted that Catherine had been represented by counsel and the terms aligned with standard equitable division of actual marital assets. Morgan tried claiming circumstances had changed since 2016. The judge asked what circumstances had changed, besides Catherine now wanting access to assets she had previously disclaimed. No answer. The legal foundation of Catherine's claims had evaporated. Every demand she had made was directly contradicted by her own signed acknowledgement that she had not participated in my business, had no ownership interest, and had agreed to predetermined settlement terms. Morgan tried to continue arguing, but the judge cut her off. The agreement was valid, binding, and would be enforced. Family court strongly favors prenuptial and postnuptial agreements properly executed with independent counsel. Catherine had received exactly that. Have you seen legal agreements completely change divorce outcomes? Share stories about binding contracts in the comments below. The judge issued her ruling 2 weeks later. Catherine would receive the settlement terms specified in the postnuptial agreement. 50% of marital home equity, which amounted to $94,000 based on current valuation. 50% of joint savings and retirement accounts, which totaled $62,000. 2 years of transitional spousal support calculated at $12,000 annually based on Catherine's average gallery income during the final 5 years of marriage. Total settlement, $180,000, precisely what the agreement specified. 0 ownership interest in Bennett Agritech, 0 interest in the family ranch, 0 ongoing spousal support beyond the 2-year transition period. The judge's written order included pointed language about the importance of honoring signed agreements and the consequences of pursuing claims contradicted by binding legal documents. Morgan filed an appeal, arguing the trial court had abused discretion by enforcing the postnuptial agreement. The appellate court rejected it in a brief order, noting that Catherine had been represented by independent counsel, had signed voluntarily, and had explicitly acknowledged understanding the agreement's implications. The appeal was frivolous and bordered on sanctionable. Morgan ended up facing a disciplinary complaint filed by the State Bar after another client came forward claiming Morgan had pursued claims despite knowing about contradictory legal agreements. That investigation was still ongoing, last I heard. Catherine attempted to contact me several times after the final ruling, wanting to discuss the settlement and her financial situation. I declined all contact except through attorneys. The postnuptial agreement had established clear boundaries and predetermined outcomes precisely to avoid post-divorce negotiations or emotional appeals. Bennett Agritech continued operations without disruption. The legal proceedings had cost me $48,000 in attorney fees, a fraction of what defending against Catherine's original demands would have required. More importantly, the company remained wholly mine, built through 28 years of independent entrepreneurial effort, now legally confirmed and protected. The family ranch stayed in the Bennett Trust, preserved for future generations as my grandfather had intended in 1953. I've since expanded operations there, adding another 240 acres through a conservation purchase, and developing an agricultural education program that brings in sustainable revenue while teaching sustainable ranching practices. The broader lesson became clear through this experience. Comprehensive legal documentation protects against future false narratives more effectively than any courtroom argument. When someone claims partnership in ventures they actively avoided participating in, signed admissions of their non-involvement become irrefutable evidence. Catherine had spent 22 years declining to engage with my business operations. She had voluntarily signed legal documents acknowledging that non-participation and disclaiming ownership interests. Those facts couldn't be rewritten with emotional testimony or creative legal theories about supportive spouse contributions. Family court, despite its reputation for favoring emotional narratives, ultimately enforces properly executed legal agreements when presented with clear documentary evidence. The post-nuptial agreement had been prepared with exactly this scenario in mind. During our previous separation in 2016, I had recognized that Catherine's disinterest in my business ventures could become a future litigation strategy, claiming she had sacrificed her career to support mine. The agreement forced her to explicitly acknowledge the reality. She had chosen independent pursuits, while I built the company alone. That acknowledgement, preserved in a binding legal document, protected everything I had built. I've advised several colleagues in similar situations to consider postnuptial agreements when there's clear disparity in business involvement and potential future claims seem likely. The investment in proper legal documentation, several $1,000s for comprehensive agreements with independent counsel, provides protection worth millions when divorce proceedings begin. Strategic preparation defeats false narratives. Documentation outweighs testimony. Legal agreements properly executed with independent representation will be enforced by courts regardless of subsequent emotional appeals. These aren't complex concepts, but they require the discipline to document reality when relationships are stable rather than waiting until litigation begins. Catherine received a fair settlement based on actual marital assets we had accumulated together. The $180,000 represented genuine joint financial contributions during our marriage. What she didn't receive was credit for business success she had never participated in, or family property protected by trust documents she had acknowledged. That distinction mattered. Ex-spouses who falsely claim partnership in professional ventures they avoided throughout a marriage deserve to face the legal consequences of their own signed admissions. I had built Bennett Agritech through systematic entrepreneurial effort over 28 years. I had restored my family's ranch through independent agricultural innovation and sustainable management practices. Catherine had pursued her own interests during that time, which was her choice. But choices have consequences, and legal documents memorialize those choices for future accountability. If this story of systematic legal preparation and documentation protecting generational assets resonates with you, please hit that subscribe button for Revenge Tales with Luke. We share stories where professional competence and strategic thinking defeat false narratives through established legal procedures. See you in our next story.